Good afternoon, everyone. I'm going to speak to you today about a perennial problem that employers face, and that is what to do about the employee who is obviously having some problem or altercation within the workplace. The most flamboyant example that results from this is the employee who storms into your office and says, "I quit," and storms out again and goes home for a few days, and you don't hear from them. But it can be a less flamboyant problem as well. And you'll see that in the case that I'm going to discuss today, Johal and Simmons de Silva LLP, which was a decision that came down just before the holidays, in which the employee is much less flamboyant than this, essentially leaves her security pass on on her boss's desk and leaves. And the question is, and the perennial question is in these cases, did these people resign? That is, can we hold them to their apparent intention to leave the workplace voluntarily? Do we have to let them come back if they say they want to? And if we don't, are we going to be sued for wrongful dismissal? And that's exactly what happened in the Johal case. Johal was employed as a senior family law clerk in this law firm, LLP, working for a Mr. Clark. She was 62 years of age and had been employed for 27 years. Now, these little facts are, of course, extremely important. You're dealing with an older employee employed for a very, very long time. So that really should get your antenna up immediately when you're looking at the facts of this case. Now, this law firm was a small firm, and it involved 4 lawyers, 3 senior law clerks, and 2 junior law clerks. And Ms. Johal had been a primary law clerk for Mr. Clark since 2008 and his only law clerk since 2011. The circumstances of the resignation issue, which became very relevant later, are that one of the lawyers resigned and another gave notice of resignation. So there was going to be a little bit of a lull in the family law activity. In the meantime, a senior law clerk was returning from parental leave shortly. And the plaintiff, Ms. Johal, and this clerk did not get along. So this is a fact that was known to Mr. Clark. So one day, Mr. Clark calls Ms. Johal into a meeting to inform her of changes being made to the practice as a result of these changes. Now, the problem really is that the 2 versions of events that happened subsequent to this are somewhat different. His version is that he told her that the lawyer had resigned, that the clerk would be returning shortly from parental leave. He had a new role for her, for Ms. Johal to assist him, but that she would continue essentially in her existing role, and he would continue to be her boss. So essentially, apart from some small changes, it would be status quo. Her version of the conversation was somewhat different. She said that Mr. Clark informed her about the resignation and the return of the other clerk. He referred to the other clerk as a project manager and said that the other clerk would be now responsible for assigning work to her. In other words, that this clerk would be becoming her superior. So these are fairly dramatically different events. Now, just as an aside, at this point I should just point out to you that this matter came to court not as a trial, but as a summary judgment motion. It's very typical these days that a plaintiff's counsel will move for summary judgment on the basis that there's no genuine triable issue, that is, there's no real need to go to trial and to try and get a speedy verdict. So in this case, these 2 sets of events were proven through affidavits submitted by Ms. Johal on the one hand and Mr. Clark on the other, and these are fairly diametrically opposed views of the events in question. Now, the next day, the versions of events also are somewhat different. Ms. Johal, according to Mr. Clark, took her personal belongings out of the office, put her security pass on his desk, and stated that he had put her in an intolerable position, and that when asked if she was resigning, he stated that she said she had hit the end of the road and left. Her version of events is that she overheard another conversation between Mr. Clark and a law clerk in which they discussed how closely the 2 of them would be working together, which upset her. That after that meeting, she went into his office and handed her security pass to him, so that's common ground. But she denied completely saying she was at the end of the road or that he had put her in an intolerable position. So Ms. Johal argued that placing her security pass on the desk and removing her belongings, things that are agreed between the parties, might look like a resignation, but that there were a whole lot of other things that should be considered. She said her resignation was an emotionally charged event. And she said, frankly, that even if she had resigned, which she said she had not, she should have been allowed to resile from the resignation. That is, she should have been allowed to come back to work when she wanted to do so. The defendant, by contrast, said, no. She was very definitive that by her words and actions, she meant to resign, that it had waited 5 days before contacting her to say that they had accepted the resignation, and that they didn't have a duty to second guess her or a duty of good faith to ask if she wanted to reconsider. In fact, they said that, in fact, they didn't have an obligation to be paternalistic towards her. That is, to operate on the assumption that she didn't know what the heck she was doing, and therefore sort of substitute their judgment for hers. Oops. So the court relied on the distinctions it saw essentially between this case and an earlier case called Gebrselassie and BCR Active Media from 2007. Now, in that case, we had an employee who was very unhappy about his bonus, about his workload, about shift changes, and about allegations about his performance. So there was a lot of conflict going on in the workplace before the events in question. Now, similar to the facts in this case, one day he came in, returned his keys, took his personal goods, and didn't report to work the next day. But effectively what the court was saying in this case is that that's essentially where the similarity ended. Now, the court in our case, in Johal, relied on comments made in Gebrselassie about how you know if somebody has resigned. And these are facts, these are statements that get repeated again and again in cases like this, either where people leave their keys on your desk or even if they storm out shouting at you. And the principle is that a valid and enforceable resignation must be clear and unequivocal. And in the Gebrselassie case, the case with the fellow who's unhappy about his bonus, he failed in that case because it was clear to the court that he had become frustrated and disgruntled and no longer wanted to work for the defendant. And in that case, the court held that it couldn't accept the credibility of his account, even though it understood the fact that in emotionally charged circumstances where people are upset, a resignation in that situation can undermine its essential voluntariness. Now, in Gebrselassie, because of the events that predated the events in question, that is the unhappiness of the employee, the court had no difficulty in holding that his suggestion that he was simply doing this in an emotional moment was really belied by the facts, and so he failed in his argument that he had not resigned. However, in this case, the court said, well, there's a superficial similarity with Gebrselassie because both of these people put their keys, passes in that case, on their boss's desk and took their personal goods and didn't show up the next day. But apart from that, there are a whole lot of other contextual issues that have to be looked at that would demonstrate that Johal's action was not a voluntary resignation. Firstly, she was 62 years old. She'd been employed for 27 years. She was a senior law clerk and the only law clerk from 2011, so she had very strong security of tenure. She was paid $60,000 per annum, which is a very good wage for a law clerk, and she worked close to home. So these are not things that she's going to give up lightly. She was called into the meeting with Clark without any notice. She received the information about the restructuring of the firm only orally. It was known to Clark that she didn't get along with the returning law clerk. In other words, that the announcement that that this person was coming back, and I think the court pretty clearly accepted there was going to be a relationship between these two individuals in terms of how the work was going to be distributed, that was going to be a problem for this person that would be well known to Clark. Clark didn't arrange a follow-up meeting in any way. He made no attempt to discuss the previous day's meeting with Ms. Johal after it occurred. He had no discussion with her when she left her pass on the desk. He didn't call her. Nobody from the firm called her at all after the meeting. And the court held, I should mention in passing, and recognized that this was a law firm in which it was clear that the firm was top heavy with family law people. That is to say, with family law clerks, that is to say that it had lost 2 lawyers. It wasn't replacing them at this moment. They had a clerk returning from leave. And so the court construed from that the firm really didn't mind particularly if this person did not come back. It didn't, in other words, work very hard at trying to assess her intention because it suited it perfectly well that she resign. And in other words, that the facts demonstrated that it had a motivation not to follow up on what her intention truly was. In this case, Ms. Johal had never threatened to resign previously. She wouldn't have a job immediately available to her. She gave no notice, so of course she couldn't have somewhere else to go. She had not stated she was quitting or resigning. And most importantly, her sudden departure was out of character. She was not the flamboyant type, the type who's constantly threatening to do this kind of thing. And while the court recognized that nobody is required to be paternalistic and second guess other people, in the context of the facts I just described regarding the downsizing of the firm and the overstocked nature of the number of clerks that they had, and in light of all the facts that I've just outlined above, the defendant was required to do something more to determine the true intention of Ms. Johal than simply say, well, I guess she's resigned then. Now, the court, however, now of course Ms. Johal had argued secondarily, and it became unimportant really in this case because it was held that she hadn't resigned, but Ms. Johal had also argued that if she did resign, she should have been allowed to resile from her resignation. And she relied on case law that supported that an employee can resile from the resignation provided that there's no detrimental reliance on the employer's part on the resignation. Now, in this particular case, the law firm argued that there was detrimental reliance. And it said, well, we told a junior law clerk who was on probation that her employment was secure, so that's detrimental reliance. And we told clients about the plaintiff's departure, and we told staff about it, and her coming back would confuse everybody and decrease morale. And so that's detrimental reliance. And finally, rehiring Ms. Johal would encourage employees to resign without notice because there wouldn't be any repercussions. The problem is that the court really didn't buy any of these arguments. It's true that the junior law clerk was notified, but the individual would have had to be notified that they were no longer on probation in the fullness of time anyway. So that wasn't important. And everything else was completely impressionistic and speculative. There was no empirical evidence about confusion or loss of staff morale, or that anybody would be encouraged to resign without notice because of repercussions. And in any event, there had been an earlier person who'd stormed out previously for a few days and been allowed to return. And so obviously in that case, that wasn't a consideration to not allowing the individual to return. So because of that, the court didn't have to resolve the question that really arises, and in which there are really 2 lines of cases. When can an employee resile from a resignation? There are some cases that say that an employee can always resile unless the employer has relied on the resignation to its detriment. And there's another line of cases that says, well, you can do that up to the point that the resignation is accepted, but after that, the employer no longer needs to prove detrimental reliance. Now, that's all kind of interesting because really, technically, a resignation is a unilateral act. It's giving notice that you're leaving, and it doesn't need to be accepted because you're going to leave whether it's accepted or not. So this is a bit of a fiction. Nonetheless, it's an interesting fiction because on the one hand, where that resignation is accepted and there's a recognition or that is going to occur, it can have an effect on whether the employee has the right to resile or not. So in Johal, effectively, because the resignation was held not to be a resignation, the question of resiling didn't come up, but the court leaned in favor of the acceptance model if resiling had been an issue. Now, interestingly, in this case, the court had no problem at all in resolving credibility issues between these parties in the manner I've described. Even though there were significant factual differences in the affidavit evidence, the background facts relating to what the firm looked like were enough for the court essentially to buy Ms. Johal's version over Mr. Clark's. And in any event, to say that in these circumstances, the firm had a very strong reason to just not make any further inquiries, which it should have done based on the facts of this case. However, that didn't end the case, because the court said, well, I can't really determine damages or mitigation, about which there was also a lot of dispute in the affidavit material, on a motion for summary judgment. And so the court ordered that there be a trial of that issue only. Now, it's my guess that that trial won't ever actually happen, because Ms. Johal is 62 years old, worked elsewhere, worked in this firm for 27 years, may or may not be terribly reemployable, and so on and so forth. So it may be that the case never actually proceeds to trial. It gets settled instead. What do we take from a case like this as employers and employer counsel? Well, first of all, this case was loaded with warning bells that should have gone off all over the place for these people, because we're dealing with a long service employee who's not theatrical, who's walking out after 27 years, and who's clearly not got another job to go to. So, and clearly there's an emotional component, even though there was a dispute about exactly how that emotion was portrayed. It was clear that Mr. Clark knew these people didn't get along. And so this reorganization of the work was going to be problematic. So when an employee is obviously emotional, you cannot assume that if they come in and say, I quit, because they're expressing their emotion, or if they are less emotional and more subdued about it in terms of the way they present, but they're still showing that they're deeply distressed about something that's going on in the workplace, you really cannot assume that they're expressing their true intention on that day. They should always be asked specifically if they intend to resign. You should always contact them the next day or after a couple of days after they've calmed down, and try to get them to express their true intentions. If there's been an unpleasant meeting or you've conveyed an unpleasant message, always follow up with another meeting to try and thrash out what is bothering the employee and get to their true intention. If you can get there and they intend to resign, that's fine. But if you decide to go on the minimal amount of information and you have a litigation situation like this, you're going to lose. It's going to be expensive, and there are going to be costs, of course, associated with that, both your own lawyer and the other side's lawyer. So it's a dangerous thing to do. Give the employee the opportunity to return to work, even after a few days have gone by, even if after there's explosive behavior, and even after, frankly, they've sworn at you. It's always a good idea not to try and make a cause case out of a single expletive when uttered in the heat of the moment by an employee who's otherwise a good employee. So always give the opportunity to return to work to protect your business from an expensive lawsuit. Make sure if you're going to deliver messages about changes that may upset people that you do it in writing, so that at least you know later what it is exactly you were talking about. Because in this case, of course, there were different versions of events and the court had to choose between them, and it chose her version. So you want to ensure that you've got certainty and clarity about what you're proposing doing if you're making changes. Keep in mind as well that if this kind of conduct of putting a pass quietly on a desk and leaving is completely out of character for your employee, that is going to mitigate enormously in favor of that not being a true expression of their intention. But the good news is, when the intention to resign is clear and you have accepted it, the employee can't resign, and that means that even though technically a resignation is a unilateral act, I would always encourage you to accept your resignation, especially in circumstances which may be touchy, to avoid the risk of the employee later seeking to return. And the good news is, too, that if you follow all the steps in trying to offering a return to work, in writing, by the way, trying to work through what the conflict is, and the employee still says, no, I'm quitting, that you'll be able to rely on that if there's litigation. And I'd like to thank you very much for your attention, and I guess now we'll move to the question section if there are some questions. And I'll turn that back over to Fred.
So we don't have any questions. We will be sending out the slides as well as posting the webinar on our website. So keep an eye on your inbox for those. We'd like to thank everyone for coming, for paying attention. We look forward to speaking to you again at our next quarterly webinar. Thank you very much.